In today's video, we'll be dealing with the concept of termination of agency. So far, we have learned that an agent is a representative of the principal, which means all the authorized acts done by the agent binds the principal with the third party. So the termination of agency means wherein the contract of agency comes to an end. So from that point onwards, the principal will not be bound by any of the acts done by the agent. There are various modes of termination of agency. The first one is by revocation of agent's authority, by renunciation of business of agency by the agent, by completion of business of agency, by death, insanity of either principal or the agent, or by insolvency of the principal. So which means a validly created agency can be terminated on any of these grounds, including insanity, death or insolvency. The first mode of termination of agency is revocation of the authority given to the agent by the principal. So this being one of the mode, there are few rules that has to be followed. First rule of revocation is that it can be either expressed or implied. That is, it can be expressed in words or also it can be implied through the conduct or behavior of the principal. For example, A, being the principal, asks his agent B to sell the house on behalf of him. Later on, the principal himself finds a tenant for the house. Now his action is clear that there is no agency henceforth, wherein the act which has to be done by the agent is done by the principal himself. So it is the implied revocation of the agency. Similarly, when it comes to a client and a counsel, wherein a counsel is the agent of the client can withdraw the contract of wakalatnama whenever he wants. So in the case of C.V. Sudhendra versus Divine Light School for Blinds, it was held that when the client finds himself losing trust and confidence in the counsel, he can withdraw the wakalatnama. Also in the case of R.D. Saxena versus Balram Prasad Sharma, it was held that whenever the contract of wakalatnama is withdrawn by the client, all the documents belonging to the client has to be handed over to the client by the counsel when demanded. If it is not handed over, it amounts to misconduct according to section 35 of Advocates Act. The second rule says that no revocation can be made when the agent has the interest in the subject matter. When the authority of an agent is coupled with interest with the subject matter, such an agency cannot be revoked. However, if there is a contract to the contrary, then revocation is possible. For example, principal owes certain amount to the agent. So, the principal gives the authority to the agent to sell his house and out of the sale proceeds to deduct the amount which he owes to the agent. So, now the agent's interest is on the subject matter. Therefore, the agency cannot be revoked by the principal. In the case of Ishwarappa versus Arun Kumar, power of attorney was given to the agent to look after the construction business. But nowhere it was mentioned with regard to personal liability or loans to be incurred in the personal capacity. However, the agent incurs loan in the personal capacity. When the agency was revoked, such a revocation was held to be proper because there was no coupled interest with this subject matter. The third rule of revocation says that it can be revoked only before the authority is exercised. Now, which means when the agent is given an authority by the principal to do certain act, revocation of agency is possible only when the act is not done. The authority has already been exercised. If the act has already been done, such an agency cannot be terminated. Which means if an act is already done, it binds the principal with the third person. Similarly, if the act is partly done or the authority is partly exercised, then in that case what has already been done cannot be revoked. It also binds the principal with the third person. The next rule is when there is a premature revocation without any justifiable cause. Now we know that agency is meant for a certain period. So there's a fixed period for agency, for an agent to do certain act. So before that particular time, if the agency is revoked by the principal without giving any justifiable cause, without giving any justifiable reason, then in that case the principal needs to compensate the agent. Similarly, the next rule says that the principal should give a reasonable notice of revocation to the agent. So when there is a justifiable reason or a justifiable cause and there is a premature revocation of agency, it should be notified to the agent by the principal, which means a notice should be given to the agent by the principal. In the case of Mrs. Om Prakash Pariwal, here the petitioners were appointed as storing agents by the Food Corporation of India. The agents or the petitioners here invested a huge sum in workmen and also in infrastructure. Later on, the agency was terminated without giving a notice to the agents or to the petitioners. Now this became a huge loss or huge damage to the petitioners. Since such a revocation was done without any justifiable reason or cause and also without giving any notice to the agents, it was held illegal. The next rule says that termination of agency also terminates the sub-agency. The sub-agents who are appointed by the agents are relieved just like how the agent is relieved from the contract of agency by the principal. The next rule speaks about the time from which the termination of agent's authority becomes effective. The rule makes it clear that the termination of agency ends the authority or power of the agent to act as a representative of the principal. However, the termination of agency comes into effect only when it is notified or brought to the notice of the agent as well as the third party. For example, a principal appoints an agent to sell the goods worth ₹1,000 for which he assures 5% commission and the agent agrees for the same. Later on, the principal does not want the agent to sell the goods. So he sends a letter saying that he should not sell the goods. But meantime, the agent has already sold the goods to the third party before receiving the letter. So that is why such a sale binds the principal, because even though there was termination of agency, the letter did not reach the agent. The next mode of termination of agency is by renunciation of authority by the agent himself. That is, just like how a principal can revoke the agent's authority, similarly, the agent can renounce the authority. The agent here has to give reasonable cause, a justifiable reason and a proper notice. If reasonable notice of renunciation is not given by the agent, then in that case the agent is supposed to make good the loss or damage that is faced by the principal. The next mode speaks about completion of agency. So once the authority is exercised by the agent, the act is complete. This act binds the principal with the third person, which means the agent is no more in picture. So that is when the agency comes to an end. The agency can also be terminated either by death, insanity, insolvency of either principal or the agent as well. For example, if a client gives the power of attorney to a counsel when the counsel is in sound state of mind and health. Subsequently, what happens is, because of the old age and feeble and weak mind, the counsel is not able to perform his duties or function as an agent. Now here the agency stands terminated or revoked. So today in this video we discussed various modes of termination of agency. I hope you're clear with the concept.